Good afternoon. My name is Marlyn Schulz, and I am a California and Texas licensed trust and estates attorney. And I just want to say thank you to the San Francisco Public Library and specifically to Jonathan and all of the staff at the Business Science and Technology Department for allowing me to present this very important topic to you all today. And today's topic is actually pretty simple. We're going to talk at a 30,000-foot view about how you avoid probate in California, because again, at least one thing is certain. So, a little bit about me. This is my educational pedigree. These are all the accolades and the things that look great on a resume. But the reason why I became an estate planning attorney was actually pretty simple. I had a family member of mine pass away unexpectedly, and this person had no estate planning documents whatsoever. And so the kinds of pitfalls and things that go wrong in an unplanned estate are the kinds of things we're going to be talking about today. Is literally the reason why I got into this, is to make sure that other people did not have to go through what I went through. Um, at the outset, I do want to say, if you have questions, again, you can absolutely use the Q&A feature. Also, if you have questions that are specific to you and you are looking for some legal advice, not necessarily something that you're comfortable sharing in this kind of format, just go ahead and scan that QR code down at the bottom. That gets you 15 minutes of my time for absolutely free so that we can talk a little bit more in depth about your estate and what you might need. I do want to say before we really get the ball rolling, though, that everything that you hear in this presentation today is not to be interpreted as legal advice. I am not your attorney, though I am an attorney. If you need an attorney, by all means, go ahead and scan that QR code or ask me for a list of references later, and we can absolutely talk about what you might need there. But until then, just sit back and relax, and let's talk a little bit about what you should expect for the next 45 minutes. So, at the outset, what we're going to do is we're going to define what the probate process looks like. And so we're going to go from start to finish, roughly what that process looks like, so that you have an idea of what probate is, what it means, what it entails in terms of your time and energy, as well as the cost. And so we can talk a little bit more from an educated standpoint, what those common issues with probate are and how to avoid them. And so we're absolutely going to take a deep dive into that. We're going to follow it up with a discussion of the components of a well-rounded estate plan. What are the documents that you actually need in order to avoid probate? These are going to be really important for you to sort of check off your list of things that you have in your own estate plan to make sure that it is comprehensive, it is well-rounded, it has been thought through before the crisis hits, which is always a really important feature here. And lastly, we're going to save some time for question and answer. So again, go ahead and use that Q&A feature there. If you have questions, we'll certainly get to them. I know that there were some questions that were posted ahead of time, and so we're going to see if we can't, sort of interweave that into the presentation as we go. But for right now, like I said, sit back, relax, and let's talk about probate. So what is probate? Probate at the 30,000 foot view, very broad generalization here. It's the process of proving up in court that an instrument is the valid last will and testament of a deceased person. That's straight out of Webster's dictionary. Although more broadly, what we're really talking about is the process of administering somebody's estate when they've passed away. There are generally two roads into probate court. One is you passed away and you did not have a will, which is something we call intestate succession, or you passed away with a will and now a court has to authenticate that document and admit it to probate. That is what we call a testate succession. In either one of those instances, essentially what we're doing is we're asking the court to either authenticate a document or to prove up a family and marital history of a deceased person and then distribute property either according to the terms of the will or according to the terms of the law. And so the good news is, even if you don't have an estate plan, you actually do have one. The state of California does provide you one through the California Probate Code, but it may not go to the people that you want to go to. So if you have children that you're looking to disinherit, or parents that you don't want to have anything to do with your stuff or making medical care decisions for you, the worst way to make those kinds of things happen is literally to do no planning at all. And this conversation that we're going to be having today, the seminar today, is meant to inform you about how to make sure that that does not happen. So from the start, again, we're either, lodging a will or we're proving up the family and marital history. And then what we have to do is we have to figure out who the heirs and beneficiaries are based on either the language in the document or who the heirs are based on the intestate succession code. Sorry, that's kind of a tongue twister for me. But once we do that, the next thing we're going to be doing is we're going to be marshaling all of the property in the estate. So by that, I mean to say anything that does not pass on beneficiary designation, anything that does not belong to a revocable trust, anything that does not pass on a transfer on death deed. So as long as those things have not happened, that's what we consider part of the probate estate. So that can be anything from real estate to bank accounts to investment accounts. Anything along those lines. If there are no beneficiary designations, if there is no revocable living trust in place, those items will ultimately become part of the probate estate. Once we have an inventory of those assets in California, we also have to have an appraisal. And that means that a probate attorney is going to be, or I should say, a probate referee is going to be assigned to that probate case to sort of double check the documentation that the probate attorney has submitted to the court for their review. That process can take some time because, as you can imagine, in well-populated counties like San Francisco County, the probate list is pretty long. 60% of Americans will pass away without any kind of estate planning documents. That number is slightly lower in California because of the threat of California probate. But the reality is people die all the time without having any documentation in place. And that, again, that probate process is very long and very arduous. So again, we're looking to avoid that. Once we've marshaled all of those assets and we have figured out what their values are, then we start making distributions, again, either according to the terms of the will or according to the terms of the probate code. And people end up getting their distribution. In terms of why this is such a problem, even though I've explained it, it seems very simple. There are reasons why you want to avoid probate. And, first and foremost is that it takes time. So that process that I just described very simply in California takes at least a year. So 12 months worth of time, you're going to have assets that are hung up in probate court, meaning you cannot access those assets in order to pay bills or to take care of property or to sell a failing stock. All of that is locked up in probate. And until there is a final distribution order from a probate court, that asset is going to sit there. And when that happens, that means you can't access it. So if we need money to pay bills, or if we need money for something else, your children, let's say, it may take some time getting that through the probate court system. The other thing that I just want to make mention of is that when I say at least a year, I do mean that very, very definitively. That in San Francisco, we're talking about an 18-month minimum at this point. I have seen probates that have gone on as long as 10 or 15 years. And this is literally because people are fighting internally. The family is fighting. They don't believe that the will is the authenticated document. They think there are other wills. They think maybe somebody signed it and they didn't have capacity. Any and all of that can just increase the time for that final distribution order to come down. And that's really what we're looking to avoid, is having to even step into probate court. I do want to say, again, because I am licensed to practice in Texas, probate takes about 6 months, and it's actually a really cheap process. And that's our next bullet point, actually, is the cost in terms of going through probate. That can be shockingly high. I don't think that people realize the cost of going through probate in California is actually it's statutory, and it's based on a percentage of the estate. So let's assume for a moment that you have a $1.6 million estate in California. It probably means you own a piece of real estate and nothing else. And if that's the case, then we're talking about anywhere from $40,000 to $50,000 in statutory fees, half of that going to your attorney, half of that going to your executor. Now, your executor can waive those fees if they are so inclined, but honestly, if they're going to be spending a year in court, I doubt that they're going to waive those fees. And so again, the second reason why you want to avoid probate is that, again, it costs money. And we want to make sure that we are transferring wealth responsibly intergenerationally. Avoiding probate is chief among those if you're a California resident. The third bullet point that I want to talk about that I think is also incredibly important to this conversation is that the probate process is public. So what does that mean? That means that you can write into the San Francisco County Probate Court and you can get a copy of someone's will and a copy of their asset and inventory projections. You can get all of that valuation information, and now you have, who the heirs and beneficiaries of the estate are and what they're getting and how much and when. Um, I know that identity theft is a problem throughout the country. So again, this is the kind of information that you don't necessarily want out into the public sphere. The other thing is, if you have minor beneficiaries or elderly beneficiaries or beneficiaries that are not necessarily good with money or susceptible to scams, this area is rife with scam artists. And again, it's literally because it's public. And the reason why probate is public is because everybody typically dies with debt. So whether that be a credit card or a car note or a mortgage payment or something along those lines, the reason why the probate process is public is because that asset and inventory needs to be available for those creditors so that they know what's in the estate to get their claim paid. So let's say, for example, you pass away, you've got a credit card, it's got $3,600 of balance on it. You have, I don't know, a 2025 Toyota RAV4, and you own a home. Let's say that, the RAV4 is on a transfer on death title. Let's say the house is on a transfer on death deed. It's very possible that a creditor can open up a claim in a probate court to satisfy their debt. Okay, so I want to make sure I'm really clear about that. Just because you're not opening up a probate doesn't mean that a creditor won't. And so just be careful about that, especially if you have relatives or elderly people in your family, you know that they've got debt. Make sure you know where those assets are. Make sure that you've got a good inventory going where you think that debt is going to be paid from. Make sure there's enough liquid in the estate to actually get it paid off before they pass away, if possible. But yeah, that probate process being public, that is a number one reason I think, almost as bad as time and money, as to why you do not want to go through probate. And lastly, and I think that this is actually probably one of the most underrated bullet points on here, you care about your family. Your family is going to be the group of people that end up having to put you to rest. And that also means winding up the affairs of your estate. And going through probate courts takes time. It takes money. It takes effort. It means time off work. It means finding daycare for the kids. It means burying somebody or cremating somebody or disposing of somebody that they really did love and care about. And now they have to go talk about that person in a very clinical setting in a probate court. And again, that is very avoidable. I can say from personal experience as a probate attorney in Texas, there is nothing quite like watching somebody go up to testify in front of a judge and breaking down, talking about somebody that just passed away. It is heartbreaking. And frankly, it is avoidable. And I think that if you really want to give your relatives the gift of peace after you pass away, wind up your affairs cleanly, make sure that they don't have to go to probate court to do it. Okay. And lastly, and this does happen because attorneys like myself are human beings at the end of the day. And sometimes they are overworked, sometimes they are underpaid. Sometimes they have drug and alcohol problems. It is very possible that you can get an attorney that is not doing a great job. This is also another reason maybe you do not want to go through probate, just you getting the roll of the dice. There are a lot of really great probate attorneys out there for sure. But it really is kind of one of those things where, you just don't know until the inevitable happens, what you're going to end up getting. So now that we've talked about, why you should try to avoid probate, I just want to move on to some common issues with probated estates in general. Let's say that you didn't get your trust done, but you have a will, so now we're going through probate. The number one issue that I see with probated estates is that there's not enough liquid in the estate, and our beneficiaries cannot afford to buy each other out. And so the reason why this is sort of a crisis is because typically what we're talking about is a non-liquid asset that needs to be split up in multiple chunks, in multiple tranches, basically. Those shares have to go out to beneficiaries, and none of the beneficiaries can afford to buy each other out. This is specifically real in San Francisco. The cost of San Francisco real estate is astronomical. In comparison to the rest of the country, it is one of the highest rated zip codes on the face of the planet. And there's nothing wrong with that. But if the only asset the family has is a family home and you have multiple beneficiaries who are working class, they may not have the capital to buy each other out. And so now what we have is fractional ownership shares of a single piece of real estate. And with the way the California system is designed, one of those children has to inhabit that home no later than a year after somebody has passed away in order to avoid getting a step up in your property taxes. And so what we want to do is we want to avoid that. That may not be possible. That might force the sale of a family home as a result. And so with just a little bit of planning, with a little bit of fine tuning, perhaps some, the introduction of some life insurance into the estate, we can absolutely create an environment where the beneficiaries have the choice. Do you want the house? Do you want the money? Do you want something else? But again, it takes some really good creative estate planning, and that's again something that you want to avoid if you do end up in probate. Another issue that is common with a probated estate, that beneficiaries do not necessarily get along or they're suspicious of each other. Death is a really stressful time frame for everybody involved. Okay, for everybody involved. People do not handle stress in the best ways. Some people turn to drugs and alcohol. Some people become introverted and closed off. Some people they go after with other people with their anger about this person's death, and they project that anger onto other people. It really doesn't matter. What matters is that if we do have a situation where beneficiaries do not get along or they're suspicious of each other, then we're opening the door for litigation. Okay, litigation in terms of a probate estate can be incredibly expensive. And what we want to do is we want to make sure that we are reducing or eliminating that as a possibility. Good trust drafting can eliminate a lot of that. I'm not saying that you can't draft that in a will, but you're still stepping into court to authenticate that will. So again, if you're looking to save that money in California, you really do want to have that revocable living trust to avoid that kind of situation. And in addition, many times when we have a will contest, it'll be predicated on incapacity issues. And if that happens, what we want to do is we want to be able to point back to a much earlier drafted and executed document to say, no, they did this 10 or 15 years before they ever had any symptoms of Alzheimer's. So this is an authentic bona fide document. This was signed during a period of capacity. There's nothing illicit about this document at all, and that's really what we're trying to do as well. But again, once beneficiaries do not get along or they're suspicious of one another, it can cause some pretty expensive litigation, and often does. Lastly, and I think this is also another underrated bullet point that a lot of people sort of forget about, distributions of assets to people who are on means-based public benefits. It threatens their eligibility for those means-based public benefits. And what I mean by that is we end up bumping them out of the resource and income thresholds that they need to fit beneath in order to maintain those benefits. And just because California may have removed those in some senses, you may have benefits, or I should say beneficiaries in other states who don't have that as a luxury. So for example, in Texas, you need to have less than $20 to $80 in a bank account, less than $2,000 a month in monthly revenue or in monthly income, one primary residence, one car. That's all you can have. Now, if I'm on that and somebody gives me a distribution of $50,000, that is going to constitute income. It is going to bump me off of my benefits, and then I have to go and reapply for that. That is not something that you want to do. You do not want to put your beneficiaries through that. And frankly, even if you don't have beneficiaries today that might have those problems, you may have them later. You don't know what the future is going to hold. Somebody can become disabled. Somebody can need supplemental security income. Any and all of that is absolutely possible. And so what we want to do is avoid a scenario where if somebody is on those benefits, there is a system in place that says if they're going to get a distribution, it goes into a special needs trust. And we'll talk more about special needs trusts here in a minute. So now that we've talked about all of the scary things that deal with probate in general, the next, I'm sure, question that is coming to mind is how do you avoid this? How do we avoid going into probate? And it's actually really, really simple. We're talking about two very fundamental principles. You are either making an ownership change to the assets that you have currently, or you are making a beneficiary change. Okay. So let's talk about that from sort of a 30,000-foot viewpoint. If you're making an ownership change, that means that you are taking it out of your name as an individual, and you are either putting it on, say, a transfer on death deed, or you are transferring this into your revocable living trust with you as trustee. As long as you do not own this individually, it is not going to go through probate. That's the point. So once we start titling things in the name of our trust, or once we start putting our homes on transfer on death deeds, or our cars on transfer on death title, you can absolutely avoid having any kind of ownership issue pop up and send you into probate as a result of that. And that's really important information. Secondly, beneficiary designation changes. I hate to say this, but it happens a lot that people forget that they have an asset, usually at a financial institution, that has a beneficiary designation and they simply have not filled it out yet. So this can happen with employee-sponsored life insurance programs. I have that a lot with my younger couples. They forget to fill it out. For whatever reason, they forget to fill it out. Somebody passes away prematurely. This account no longer has a beneficiary designation on it, and now the proceeds have to go through probate. Again, simply avoidable. Just go back and double check that your beneficiary designations have been filled out. There are specific beneficiary designations, again, for treatment in terms of IRAs and 401ks that you're going to want to use versus what you would use for other assets, and we can talk about that a little bit later. But basically, those are the two roads out of the probate courtroom. It is ownership changes and beneficiary changes. And those are really key tools to remember and use. So how do we use those principles in your own estate plan? Let's talk about that. So first, if you have a will-based estate plan, which I do not recommend in California, if you have a will-based estate plan, you're going to want to make sure that, again, you have pay on death designations, transfer on death deeds, or ladybird deeds. And that's what that alphabet soup of lettering looks like under that second bullet point. Pay on death designations are exactly what it sounds like. You put a pay on death designation on a bank account. When the account holder passes away, that person named and that pay on death designation ends up taking the funds. Okay. It avoids probate. It's a non-probate transfer. It will never see the inside of a courtroom unless that person has passed away, unless that beneficiary has passed away. Because what they don't do is pay into the estate. They're going to be looking for a contingent beneficiary. And if it's not there, then this ends up back in that person's estate. And that can be a problem. Transfer on death deeds. Really simply, a transfer on death deed says, if I pass away, this parcel of real estate goes to the beneficiary listed on this deed. It's as simple as that. I have seen, especially in Texas, I have seen people put their homes on transfer on death deeds in order to avoid Medicaid payback programs. You don't have that problem here, but I will say a ladybird deed is also the similar type of document that is used for that same purpose. Again, avoiding probate by putting it on a transfer on death deed or a ladybird deed. Next up, what we're going to do is we're going to talk about trust-based estate plans. And again, all property that is properly titled in the name of the trust, or I should say in the name of the trustees of this trust, avoids probate. That can cover pretty much anything. So that's your homes, that's your investment accounts, your bank accounts, that's your crypto accounts. Any and all of that can be transferred into the trust. And a fully funded trust is a happy trust because, again, it avoids probate. I will say that the number one way that people with trust-based estate plans end up finding their estates in probate is typically through inheritance. So let's say that their parents died in another state, they left them a piece of real estate in another state. They pass away here, all of their California situs assets are in their California trust, which again, their probated, or I should say their estate planning attorney did their job and talked to them very heavily about funding. But oh, they forgot that one piece of property in North Carolina or Texas or wherever. If that's not located, or I should say, if that's not retitled in the name of the trust, that means it's going to go through probate. Okay, it's going to go through probate one way or another. And so what we want to do is make sure that every time you inherit something, every time you buy a piece of property, every time somebody dies, you are revisiting that estate plan to make sure that you've got all of your property retitled properly in the name of the trust. Okay. Also, in terms of using those principles for your advanced healthcare directives and your durable powers of attorney, again, what we want to do here is we want to make sure that the people that we've chosen to make financial and healthcare decisions for us are really good under pressure. I think that's probably the number one attribute that you want your agents to have in terms of this. You want to make sure that you have advanced healthcare directives and durable powers of attorney so that you can avoid a conservatorship in a probate court. That typically happens when you are incapacitated long term. And it is inappropriate for somebody to make healthcare or financial decisions for you under the guises of either having no healthcare or financial directives or having one that maybe doesn't list the right people or not necessarily the right people, or maybe the people that you've named are no longer willing to serve. That's also another way. When we start putting a conservatorship in place, you're going through a probate court to do that. And so without advanced healthcare directives and durable powers of attorney, that is a way that you can find yourself into probate court as well, simply by not having those documents. So again, proper people in terms of your advanced healthcare directives and durable powers of attorney, they need to be good under pressure. Okay. If they're going to be an agent under a healthcare directive, they need to know what your healthcare preferences are, or at least be able to extrapolate what your preferences are based on what they know about you. Because if they don't know, they will have the power to guess. This came up a lot during COVID. You absolutely want to make sure that you have concise conversations with your friends and relatives, whoever is on your advanced healthcare directive, what your preferences are. It doesn't make a difference to me or anybody else in the medical community what your ideological perspective is. What matters is your preferences. And that's really what we need to put on paper. So you want to make sure you have that. Your advanced healthcare directive should be bolstered by a standalone HIPAA authorization so that people in your circle can access your medical records in the event that they need to, and also bolstered by a physician's directive. A physician's directive, it curtails the possibility of being in a coma and having people litigate over whether or not to terminate life support. I'm going to date myself a little bit and reference Terri Schiavo. This happened probably about 35 years ago in Florida. She was in a car accident, I think, and her husband had stated that she never wanted to be in a vegetative state, and she was telling the hospital that they needed to pull the plug. Her parents fought back on this, and for 10 years, this woman languished in a coma. There is 10 years of litigation, 10 years of medical bills piling up. And again, it really doesn't matter where you find yourself in terms of that, in terms of that decision. You need to be able to make it and let other people know what your decision is. And a physician's directive, again, is really good at saying to the medical community, if I'm ever in that kind of state, this is the directive to my physicians and my agents. Very important. Next up, the durable power of attorney. This is very similar to your advanced healthcare directive, but this is a document that handles financial decisions in the event that you're incapacitated. The language governs all varieties of real and personal property. So when I say real property, I mean real estate. When I say personal property, I'm talking about the things like all of the cute pictures behind me and tables and chairs and linens and dishes and all of that. That covers all of that, plus all of your finances as well. Okay, so you want to make sure that you're really careful about who you pick to make those kinds of financial decisions. So not only should they be very good in under pressure, but they should also be really good with financial acumen. I did see your hand up, Denise, and I will get to you in a second. The other thing I do want to say is that the durable power of attorney language should also include language about detention by law enforcement as a triggering event to spring into effect so that people can get a hold of your property. So if they need to bail you out or they need to, pay for an attorney, they can do that. I am seeing this a lot in Texas lately and with a lot of my California clients as well, that they are using their durable power of attorney so that somebody can manage their finances if they are detained by ICE. We live in some very strange times. I'm sure I don't have to tell you, living in Texas and having been in San Francisco for a number of years myself, there is polarization in terms of politics. I have no idea what is going to happen in the next 10 years. I don't think anybody can really predict that. But I can predict that if ICE is as funded as it is, as well funded as it is, you are really going to want to have language in there that says, if I am ever detained by law enforcement for any amount of time, that this document triggers, and we are capable of managing your finances. And I'm just going to pull up the Q&A here because it looks like we've got some questions here. So the first one is buying each other out, meaning to buy another person's share. That is correct. That is 100% correct. We want to make sure that there is a way for somebody to buy a share of the property if they can. So that's why we introduce life insurance, so that there's a cash payout. They can opt either to use the cash to buy the house or simply keep the cash and give up their share to the other beneficiaries. For life insurance, investment, and retirement account, should we use the trust name or put specific beneficiary names? Which is better? So for life insurance, you want to name the trust as the primary beneficiary. And same thing for investment accounts, always name the trust as the primary beneficiary. But for retirement accounts, it really depends on whether or not they are qualified retirement accounts or non-qualified. So the rule of thumb is really, if it's a retirement account, name your spouse, if you have one, as the primary beneficiary on that retirement account, because they get beneficial tax treatment once that is rolled over to them after you pass away. After that, name the trust as a secondary. If your kid is an adult, should I put the kid as the primary? Oh, hold on a second. It's being scrolled away there. Should I put the kid as a primary or secondary contingent beneficiary? What's the difference between secondary and contingent? If your child is an adult, I don't have a problem. And by adult, I mean over the age of 18. You can theoretically put your child as a primary or contingent secondary beneficiary. And we can use secondary and contingent interchangeably in this sense. That really is no difference. But really what we want to do is we want to make sure that your child has the financial acumen to manage money. If they don't, and you're handing, let's say, a grief compromised 25-year-old access to, say, your entire retirement account, statistically, this is not going to end well. It really sometimes doesn't matter what kind of financial background you come from. Sometimes it takes as little as 18 months for that to be spent through, and I'm sure that's not what your intention was for that money. And that's, again, why I definitely recommend people getting a revocable living trust with age-appropriate tranches of payouts. So if you want to stretch this out over time, 25, 30, 35, and 40, those are really good milestones for years. Your needs at 25 are not the needs you have at 40. And you really want to make sure that you stretch that out. That's another way to do it as well. Instead of a TOD for an automobile titled in California, does title with both names, parent and child, with or enable a child to sell the car after the child passes away? To my knowledge, yes. I have seen people title this as or, and again, if it's not one person, it's another. When somebody passes away, that name drops off title by going to the DMV and presenting a death certificate. Then they simply reissue title in the name of that surviving child. So my understanding is that yes, you can do that. They can sell the car after the parent passes away. So the next question is about a pour over will to capture any assets that were not titled in the name of the trust if the parent has a trust. That should be a component of your estate plan, frankly. If you have a trust-based estate plan, you have to have a pour over will. And it's exactly what our anonymous attendee said there, that if you have a trust, that pour over will basically says, if this document is seeing the light of day, it's because I forgot an asset outside of my trust, and now we need to probate this will to make sure that it's part of the trust. In California, we also have something called a Hegstad petition, and that can sometimes eliminate the need for going through a full probate proceeding with a pour-over will, provided you can prove that this was always meant to be part of the trust property. Typically, this happens when we go to refinance a house and we simply forget to put it back in after it's done with the refi. That may be a reason to use a Hegstad petition, but again, that's a little bit more deep dive into the probate world, and we can talk about that if any of you have specific questions. But you should have a pour-over will if you have a trust. And what kind of documents or instructions do you recommend estate plans include to prepare adult children for future responsibilities? This is a great question coming from a colleague of mine. Her name is Carly Ebenstein, and she is fantastic. I can't recommend her enough if you're looking for life insurance. I know I'm not supposed to solicit, but I'm just saying if you're looking, maybe look at her. So what documents or instructions do I recommend estate plans include to prepare adult children for future responsibilities? I recommend that there is some sort of asset and inventory in the back of your binder if you have an estate planning binder. So that way we can marshal all of those assets in quick time. I do also recommend that not necessarily documents or instructions, but that you've introduced your children to those assets so that they know where they are. One of the biggest problems we have in trust administration land is literally finding where all of these assets are. And if we can't go through the mail and we don't have a key to the safe, we might have a little bit of a problem. So as much and as hard as it is, I know that culturally we have a tendency to want to shield our children or at least deny our children information about what we have and what we're getting because we're just brought up that way that we don't talk about money. The problem is that creates a lot of problems later on in terms of trust administration and certainly in terms of winding up the affairs of somebody's estate. If they don't know where things are, this can be a problem. If they don't know who your financial advisor is, if they don't know where your bank accounts are, all of this can be problematic. So I do recommend that you start having conversations with your children when they are old enough to manage those kinds of things. So we're talking about maybe 25, 26, 27. They should start having those conversations with you. Other documents that I recommend, if you've got an estate planning binder, show them where it is. Just show them where it is. They don't need to know everything, every last detail about anything that's in there. They just need to know where it is so that when something happens to you, they're well prepared in terms of that. Great question, Carly. I appreciate you being here. How do you add a new bank or brokerage account to the trust? Should I redo a new trust or put a list together and include it in the trust binder? So banks and brokerage accounts are kind of like a weird sort of animal. When we start talking about titling banks and brokerage or bank and brokerage accounts into the trust, a bank is typically going to make you close an existing account and open up a new one in the name of the trust. And this is part of a very unethical practice called gaming. And basically what they're doing is they are upping their new account numbers for their shareholders, even though they've just closed an existing account. It's unethical. It's not illegal. They all do it. And so what I do recommend you do is if you were going to go that route and you're going to retitle, or I should say, open up a new trust bank account and you're going to transfer existing funds over and close an existing account, go through the last 3 or 4 months of your statement and just start highlighting the transactions into and out of that account that are electronic and easily forgettable. Things like Netflix, I'm not so much worried about. You can always, reset the card on that. But when it comes to homeowners insurance payments or life insurance premiums, those are the kinds of things that you absolutely do not want to forget to pay. So you want to make sure that you've got those set up in the new account, and that your HR department, obviously, or Social Security, if you're getting a Social Security check, they know to change the account number and routing number as well. Brokerage accounts are a little bit different. Typically, brokerage accounts, they don't have any problems with simply adding the name of your trust to an existing account. If they do make you open up a new account, the transfer over is really not going to be as painful because you just don't have that many transactions into and out of that type of account. When you ask, should I redo a new trust? I don't necessarily think so. If you've already got one trust, you just need to restate it, or you need to amend it, or you need to upgrade it to current tax language. Don't get a brand new trust every time you do this. Just get one trust and maintain it over and over again. Every 3 to 5 years, you should be revisiting this anyway. You do want to put a list of those assets together and put them in your binder just to put a finer point on it. How do you update the trust if you no longer need the guardian as your child is adults now, or your children are adults now? Do we need to do a new trust? No, again, you simply need to amend the trust. Go to an estate planning attorney. They will charge you an hourly rate for something like this. If your trust has not been revisited in 10 or 15 years, they are probably going to recommend that you redo this because it is that old. But at that point in time, it's time anyway, right? I mean, if you've been keeping up with it every 3 to 5 years, and now is the time to put that back together and maybe revisit the language. Because again, indeed, the tax code has changed. We have the one big beautiful bill, which I'm sure we're all excited about. I say that pejoratively. But what we do want to do is make sure that, we're keeping an eye on, what that trust language looks like and that it is contemporary with what the Internal Revenue Code says. What happens if you plan to move to another state? That's an excellent question. So as I told you in the past, I'm licensed to practice in Texas and in California. We've had a lot of Californians move to Texas, and I welcome you all. I don't care what anybody else says. You guys are great. But really what ends up happening is that if you have a trust-based estate plan, you need to restate that revocable living trust to Texas law. And the reason for that is simple. Our property tax code is very different than the property tax code that you have in California. You do not want California law governing a Texas piece of real estate. It's a mess. Also, our wills are different. So in California, you do not need to notarize your will. In fact, a notarized will in California is unheard of. Here in Texas, if it's not notarized, you have to have two witnesses and it needs to all be in your own handwriting. That's a big difference. That's a really big difference. And so, yes, you absolutely do need to upgrade your estate plan to your home state's, your new home state set of laws. Absolutely. It does make sense to create an estate plan in California and then update for the new state later. I can't stress that enough. If you are living in California, have a California estate plan. If you are living in Texas, have a Texas estate plan, especially if there's real estate involved. I can't express to you how important that is to make sure that the code system lines up with the taxes that you're about to pay. It can be really, really messy. Great question, by the way. Olga says, my mother put my name on all of her bank accounts. Will this protect those assets from probate? So it does protect those assets from probate because theoretically it means that you should be able to assume control and ownership of those assets. But in California, you really do want to make sure that there are rights of survivorship language in that account. So go back and make sure that your mom, and when she put your name on there, she says with rights of survivorship, or there is a right of survivorship language in there, just to put a finer point on it, because that will ensure that it does avoid probate. Otherwise, you're joint tenants, and that means that she can, that one half share of hers can go through probate. We don't want that. Make sure there's a right of survivorship language on that account, please. Can I touch on the affidavit process for a small estate? I read you have to wait 40 days. So the small estate affidavit, I do want to say it's 40 days, 60 days, something along those lines. But essentially what it is if your estate in California is below, I want to say it's 183,500, which I mean, it's very modest by California standards. If you have an estate that's worth less than that, what you can do is you can fill out something called a small estate affidavit. It is a non-court document, basically, especially if it's only dealing with finances. So like you've got a bank account or something like that. That is simply a notarized document that you take to the financial institution, and it basically goes through the family marital history again and says, these are the rightful heirs that I have signed to and sworn to this as truth. And then that financial account holder institution, they'll release the funds to the heirs in those checks. If it involves real estate, you do actually have to go through the probate court system. A probate referee will be assigned to that. It's a much smaller process. But it can be done, and it does require much less time and effort. Although if you have a piece of real estate in California that's $183,500, $499, let's say, that's amazing, but it's probably this big, right? It's probably about that big. That is something that you're going to want to sort of figure out and retitle. Although it could be like an acre in the desert, which has happened to me in the past. But yes, you can absolutely use a small estate affidavit for real estate as well. Would a trust help non-spouse beneficiaries save money on taxes on inherited IRAs? No, they won't. Inherited IRAs are governed under a federal body of law, and basically that tax code treatment is, unless you are, and it's called the Secure Act, by the way, unless you are a spouse or one of 4 or 5 other different types of beneficiaries, if you have a non-spouse who's inheriting your IRA, they have 10 years to remove all of the funds that's in that account and then pay all of the tax that's due. So a trust does not help a non-spouse beneficiary save on taxes on an inherited IRA. And I wish I had better news for you, but Congress did not do us any favors by passing the Secure Act. There's a woman, her name is Natalie Choate. She is the world's foremost authority on inherited IRAs. I recommend that you look her up if you have questions about how those work. She is extremely smart, but the material is very dense. So get a lawyer. Do yourself that favor. Lastly, what's the advantage of having a professional do these documents versus using default forms? So I think I need to illustrate this with a story. If you go online and you decide to draft up your own trust and estates plan, or let's say you draft your own will, you don't know what you don't know. And unfortunately, AI is not as good as people claim. So when you go to trust and will, there can absolutely be problems with doing that. I have seen people take a trust and will document and basically remove all of the things that they thought were not necessary to that document. And unfortunately, it landed in probate because necessary language was removed on the part of this person thinking that it wasn't necessary for it to be in there. You are paying a professional to take on the legal liability if your documents don't work. And I think that that's actually the peace of mind that you're looking for, especially in terms of an estate plan, is you want this to work. It's rare that if you have a very simple estate, that this is going to be something that you could just pass on with your own, handwritten will. But the reality is, if you have the time, and we all have the time, get it done professionally. Do yourself a favor, do your family a favor. Do not rest this in the hands of what you thought you learned on the internet. The internet is a really bad place for misinformation. We all know that. You're not going to know what you don't know. Okay. And a lot of attorneys will also not review your own documents that you've done through trust and will to render a legal opinion. A lot of them will not do it because then they take on the legal liability for your mistakes, and they don't want to do that either. Next question. I'm on joint title with my brother and my mother on a property title. Will my mother's portion be probated? I'm on joint title with my brother and my mother on a property title. Will my mother's portion be probated? It depends on how the title is titled. So if there is survivorship language in there, no, it's not going to be probated. So basically what we're saying is if there is a survivorship language in there, then the remaining tenants split up your mother's share. So that would be you and your brother. And when one of you two passes away, the last one absorbs the entirety. Okay, so that is titling language that you're going to want to make sure that you understand. And again, get an attorney, find a title company, any and all of that's fine. The child, not more or greater than 23 years old, has his own separate car insurance, not linked to the parents. We also have umbrella insurance. If the child has an accident, can the opposite side chase after the parents' assets, even if my child has their own car insurance? So this is more like a creditor claim question. It's a little bit outside of the scope of what we're going to discuss here today. What I can say is that if you're co-signing on anything, that is a reason to get attacked by a creditor. If they are joint tenants on anything of yours, that's a reason to have your assets exposed to a creditor, although you may not be personally liable for it. So if he's got his own separate car insurance and you have umbrella insurance, I mean, chances are they're going to go through his insurance first, but I don't think that there would be any reason, again, that they would be able to attack your assets when they're not in his name. So that's something to consider. But again, I can't say definitively. I'm not a claims attorney. Last question. Please give your contact info for those of us without devices to read QR codes. Yes, our last slide is actually going to have that. So I appreciate the ask, and we'll make sure you guys get that. So the last document that I wanted to discuss before we move on to the next slide, and I know we may be running a little bit over time here today, but the last document I want to talk about is the guardianship nomination for minor children. This document, I can't stress enough, is actually probably one of the most important documents that you are going to sign as a parent. This document says who is going to take custody of your children in the event you become incapacitated or you pass away. It gives you a lot of room there to say who you want, who you don't want, and why. At really good estate planning attorney offices, especially if you are, let's say, a divorced parent and you have a court case against your spouse and you do not want your spouse to ever maintain any kind of guardianship rights or parental rights over that child, or they've lost their parental rights, you're going to want to include that case file as part of that guardianship nomination. At the very least, reference that docket number, so that way somebody in the family court knows this happened, and this person should never be a custodian. You also should have language in there that says the people in your family who should absolutely never be guardians. So I have family members who I adore dearly, but they have some pretty serious drug and alcohol problems, and I would not want my children in that house for any extended amount of time. I certainly wouldn't want them being brought up by them. These are things that you might want to consider in terms of that guardianship nomination. So next up, what should your estate plan accomplish? I think this is actually pretty simple. First and foremost, if you are a Californian, your estate plan really does need to avoid probate at all costs. Again, the time, the cost, just the sheer publicity of it. If we're not avoiding probate, what are we doing? I don't even know. In fact, I've understood California case precedent that going through probate with a trust-based estate plan as the drafting attorney can sometimes lead to a malpractice claim. So just be careful. But again, you want to avoid probate. That's just the first order of business. Secondly, you want clear and concise language identifying your executors and trustees. And I know that that sounds really strange, but the reality is what you don't want are people litigating over who's going to have control over the estate. Have a clear lineage plan. I have seen people name their children as joint executors or joint trustees. I recommend generally against doing that because limitations of liability do not apply when you have joint executors or joint trustees. What one trustee does, the other one can actually get in trouble for because theoretically they should have known that it was happening. Same thing with executors. So do yourself a favor, limit your liability to one person at a time. Make sure that it's very clear who's supposed to be doing what and when. And again, make sure that you pick people with good financial acumen and people that are very good under pressure. Or at the very least, people who know to get an adult if they don't know what to do. And sometimes that ego can also be a problem. Not being able to ask for help, that can also be a problem. Okay, so just be aware of that. You also want clear identification of heirs and beneficiaries. I know this also sounds strange, but I have had people write into a probate court suggesting that they are an heir or a beneficiary of an estate simply because the will did not say, these are my children and these children only. Just because that sentence did not appear anywhere in the will, I've had people write in saying, no, I want to be treated, as a beneficiary. Well, great. Now we get to pay for a paternity test just because those words didn't appear. Preventable, very, very preventable. Certainly, it should affect. It should have a good effect in terms of transfer of property to reduce conflict. You want to make sure that, again, that the distribution scheme is there to make sure that we're not creating problems. Again, we want to avoid fractional ownership interests of real estate if we can. We want to introduce that life insurance in there if we can. There's a lot going on in an estate, and again, just some good effective planning can make sure that any kind of hiccups are anticipated, dealt with, and dismissed. That's the whole point is having a good plan. And again, getting an attorney to help you do it is really the best way to do it. Also, you want to reduce or eliminate tax exposure. That is something that really only an attorney with a good command of the tax code is going to be able to do. You can find out a lot on Google, but you can also get a lot of misinformation on Google. Do yourself a favor, pay somebody to take on the legal liability of their interpretation of the tax code as it pertains to your estate plan. So, what should you look for in an attorney? Let's start with that. Personally, your attorney should have experience. It's subject matter experience that we're referring to. In California, it's very rare to find what we refer to in Texas as a generalist. Generalists in Texas practice everything from estate planning to probate to real estate law to criminal defense to DUIs to tickets. I mean, it's like the haberdashery of legalese. And there's nothing wrong with that as long as your practice is relatively small, as long as you're not dealing with high net worth clients, as long as the things that you're doing are relatively simple and rote. When it's like a non-contested divorce, that's fine. But in terms of estate planning, because the tax code is so interwoven into the estate plan, it really behooves a Californian to get a good California estate planning attorney. Ideally, they should be board certified. Again, the estate plan is dependent on the tax code and the probate code. And ultimately, if we do not have a good command of that, if you have an attorney that doesn't have a good command of that, you're risking the continuity of that estate plan. And we don't want that to happen. That's literally the point. You really do need to be conscientious of that. The other thing that I want you to be careful of are trust mills. And this happens quite a bit when you have a law firm that spits out the same trust over and over and over again without a lot of customization in terms of that distribution language, without taking a deep dive into your family dynamic and basically just saying, here, sign this. We want to avoid that. That happened a lot in the 90s and the aughts, and we really do want to avoid that as a practice. You need to find out, look on their Google webpage, find out what their reviews are look like, and ask for some references. That no attorney is going to deny you that. Okay. You also, again, as I mentioned, they have to have experience with the tax code. I think I don't need to beat that to death. But in terms of the person, it is actually all about their demeanor. So again, attorneys are just like everybody else. Okay. They're human beings, and some of them are really, really good at explaining things. Some of them are really, really bad at explaining things. Some of them are overworked, and some of them are underpaid. I hate saying it, but that can also lead to a very negative experience at a law firm. If they're an associate and they're being treated poorly, you're probably not going to have a good time. I hate saying it. That's just the way it is. Your attorney should always be listening to you. Okay, they should be always listening to you. It is their job to make sure that your family values, the things that matter to you, are reflective throughout your series of documents. If that is not happening, you're in the wrong office. I can't stress that enough. They should be asking you questions about your family dynamic. Again, colloquially, what we don't want to do is we don't want to put the drunk uncle in charge of the kid's college fund. And so if they are not asking you questions about substance abuse, if they're not asking you questions about family conflict, if they're not asking you questions about whether or not your beneficiaries get along or the kinds of things that we need to watch out for in this estate plan, this is the wrong office. Okay, it's just the wrong office. They need to be asking questions along those lines. Um, Thirdly, are they asking questions about how your property is titled? So remember when I started talking about that, survivorship language and whether or not it's there, that is so important to the estate plan. If they're not asking you questions about that, or if they're not pulling deeds for you, if they're not pulling titles for you, you may want to think about going to a different attorney. Just putting that out there. And lastly, I'm a big believer in this. Do you get a good feeling from them? So when you talk to them, do you feel like they're trying to understand you? Do you feel like they empathize with the things that are going on with you? I really do think that, some people just have good client side manner. Some attorneys just have great client side manner, and some people are just really bad at it. And there's nothing wrong with that. But if you're looking for, especially in this field where we're talking about a really sensitive subject matter and, something that's, really explosive in terms of emotions, you really do want to have somebody on your side that is empathetic and who is willing to listen, and somebody who can and does go the extra mile for you, because again, this is a really sensitive topic and people get upset all the time. So you really do want to find somebody, you really do want to find a law firm that feels like home, I guess is probably the best way of putting it. So that brings me to the end. I'm going to ask if we have any questions, but the last slide I'm going to put up so that way you have my contact information and again that QR code. Thank you, Jonathan. I appreciate it.
Thanks, Marlon. That was great. And so many great questions from our audience. Um, we do have a few questions from the registration forms, some that came in just in the last 24 hours. I don't think I had a chance to forward those to you.
Sure.
So I'm going to combine two of these because I think they are on a similar topic. So is a living trust necessary if the estate is mostly cash and retirement accounts? The other question is, if I have no real estate and all on beneficiary, what's the advantage of having a professional draft my uh, document?
Sure. So again, if everything is on pay on death, if everything is on a beneficiary designation and you have triple, quadruple checked that those beneficiary designations are filled out properly, then the gamble that you're taking basically is that all of those beneficiaries survive. Because again, we're not going to go through those people's estates. We go to the next beneficiary on the list. And if all of them have passed away, then that means that this is in your estate and now it's going through probate. So the reason why I recommend putting together a revocable living trust for those kinds of estates is there will be language in your trust that says, if not to this person, then to their descendants. And typically, descendants means that person's children, grandchildren, great grandchildren. So you've got a continual lineage as long as people continue to have children. There's also language in your trust that should say who is the beneficiary of last resort. So if we get down to the end of the list, and let's say we have another COVID event and entire generations are wiped out, this beneficiary of last resort is going to be like a charity or some other organization that will likely survive a pandemic or something along those lines that ends up taking the distribution if there's nobody left to take it. So again, you want to keep it in the family. You want to make sure that you don't get to the end of a beneficiary designation list and find out that you're going through probate the hard way. Having a trust really does put a backstop on it. So that really is, in my opinion, that is the best way to do it. The belt and suspenders approach, as lawyers like to call it.
All right. Another question. Can your California residence be transferred to the living spouse automatically like a joint bank account?
I'm not sure I understand that. So, like, does that mean that if I have, like, say, person in Texas, person in California, and the person in California wants to transfer their residence over to the Texan, I don't think you can do that. I think they actually have to be domiciled in the home state. That's my understanding. But honestly, if you were going to attempt to do that, I'd want to go the other way because Texas doesn't have a state income tax. So if you were looking to really reduce exposure in terms of what you should be paying, I would definitely go the reverse of that. But again, I don't know that I necessarily understand that question.
We have a few more questions in the Q&A window if you want
Sure.
to take a look at those.
Sure. Okay, here we go. Should spouses have different wills or trusts? Typically speaking, what I see in my married couples, spouses typically have one revocable living trust between the two of them and two different wills, so one apiece. And again, those wills are pour over wills, but you should have a marital trust. You should absolutely engage in doing something like that, unless perhaps you have a prenuptial agreement that might give you cause to have separate trusts. But again, you'd have to read through the language of the prenup to see what exactly the terms and conditions of it are. But generally speaking, if I've got a married couple and there is no prenup involved, they have one trust and one will apiece. Great question. And thank you, Carly, again for the compliment. I appreciate that. Um, if I'm married and neither of us have children or close family except older siblings, do I still need a trust? Yes. And again, for the same reasons that I outlined before, people pass away all the time. And if your property is supposed to go to that sibling and they no longer exist, where is it going? Is it going to their estate? Because you would need to say that. Is it going to their descendants? You would need to say that as well. So again, I really feel if you're looking to, again, put that belt and suspenders approach to it, beneficiary designations on everything, obviously, but I mean, go ahead and put the trust in as that primary beneficiary. So that way it all flows through and that your distribution provisions prevail over that, completely avoiding probate. In general, an executor cannot also be a beneficiary? Question mark. Not true. In many instances, that is very often the case that you have an executor who is also a beneficiary. You see this a lot, especially when we're probating a will and its husband passes away, wife is beneficiary and executor. So you'll see that a lot in terms of a relationship, or if wife passes away, leaving property to the children, and one of the children is an executor. That happens all the time. Same thing in trusts. Typically, one spouse passes away, the surviving spouse ends up being the sole trustee. When they pass away, distributions to the children, one of the children becomes the successor trustee for the entirety. So there's nothing in the law that says an executor cannot also be a beneficiary. There's nothing that says that.
I think that's all we have in the Q&A window. There was another pre-submitted question that I think probably a lot of people would be interested in hearing the answer. Is about what it costs to create a trust, or could you go over like what people should expect when accessing
Sure.
these services?
Sure. So in California, let's say that we have two spouses, two children, a piece of property like a house, two cars, whatever. Middle income. Okay. So very, very vanilla, very basic estate plan. That basic estate plan in California should run you somewhere in the neighborhood of about $6,000. Okay. That should include healthcare and financial directives for both spouses. It should include the revocable living trust and all of the ancillary documents that we need to fund that trust. It should also include the transfer of the primary residence into trust on behalf of the beneficiaries. So again, it should be from stem to stern a comprehensive estate plan. And if the children are minors, it should also include that guardianship nomination that we talked about before. So all in, now we're talking about $6,000. If we have a different variety of assets, let's say that we've got a business owner and they've got a business that's in the millions, and we're trying to freeze the value of that business and maintain some exemption amount, we may start employing advanced estate planning techniques like an IDGIT, or which is short for intentionally defective grantor trust, and we can talk about that in an entirely different seminar. But basically, there are different trusts for different types of assets, again, for the purposes of either freezing or eliminating estate tax exposure. Basically, we really want to make sure, especially now that we're at a 13.99 million per person, Next year it'll be 15, I think, for inflation. So theoretically, a married couple could die with 30 million in their estate and never pay a dime in taxes, which is insane in my opinion. But I hope we all have that problem one day. But if that ends up happening, you've got those kinds of assets. Maybe you've got cryptocurrency. You definitely do need to speak to a probate, or I'm sorry, an estate planning attorney that is familiar with those assets and who knows how to structure your estate plan to reduce or eliminate estate tax exposure. It's just that simple.
Great. Well, I think we've covered everything, and there were so many great questions. And thank you for getting through all of those, Marlyn.
No problem.
Um, so I think we're a little over time. We're gonna wrap things up in just a moment. I want to thank you again, Marlyn, for joining us today. It's always so great when you have a chance to come share all this important information for folks. Estate planning is one of the areas that we get the most questions about it at the library. So this is a really valuable resource to our patrons. Um,
Absolutely. Thank you for having me again. This is always a good time. Anytime you guys need one, I can do it.
oh, we'll definitely be having you come back soon.
Fantastic.
Um, and thank you everyone for joining us today. I know we lost some folks around 1 o'clock, probably had to head back to work. But yeah, thank you everyone for joining us. Keep an eye out later this afternoon. I will send a follow-up email that will have a link to a recording of this presentation, a copy of the slideshow, as well as an evaluation survey. And I want to do a plug for the evaluation survey because we don't the response rate is not great, but it really only takes a moment, and we take those very seriously. It helps us improve our programs, and it also gives us ideas for other programs to
Right.
offer. So we've some of the programs we've done have been the result of suggestions that people made in those evaluation surveys. So please, it really takes a minute or two. Fill that out. Let us know how we're doing, what you'd like to see at the library. And I look forward to reading your responses. Um, so thanks again, Marlyn. We'll have you back soon.
Absolutely.
And everyone, have a great afternoon.
Take
Take
care now.